Okay, you are ready to go.
All right, this is the Board of Zoning Appeals meeting for January the 28th, 2021. This is an electronic Zoom meeting. So to start the meeting, we will do the election of officers. And I guess you guys can just kind of make nominations from the screen here and however you want to do that. And then it won't be a secret ballot this time because you have to say who you want and how you're voting. So,
All right.
so first will be for president.
Any volunteers?
Any nominations?
Mr. Chairman, can I kind of kick this off?
Go ahead. Go ahead.
So I have great respect for all of my fellow board members. Dave, I've really admired your leadership over the years. You're a super smart guy with a calm demeanor. Bob, you're extremely knowledgeable and really detail oriented. And of course, Ashley and Doug play important roles and contribute in major ways. Having said all that, I'd like to cast my vote for the status quo.
Who was the secretary last time? Were you guys sharing
Carrie and I
was going to
share.
volunteer at this time.
I think Ashley and I would be happy about that, Doug.
I didn't know if you were all going to be upset with that or.
I have a question about that. Would our recordings not suffice? Do we have to have a written documentation?
Well, even if we do the Zoom meetings, whatever, if we make decisions on a case, I still need a signature, and that's why you guys were coming by town hall and signing the paperwork. So I've still got the signatures on the case, but it is easier as far as it put minutes in a file with with that date or that case or whatever, and then in the future when somebody looks at it, they may not have access or be able to get to the Zoom meeting. So I would think we still need the minutes.
Yeah, and Harry can correct me if I'm wrong. I believe that the minutes are the only actual record of, the only official record of the meeting.
I like the minutes.
I don't know what records are kept. I thought that that the BZA was supposed to prepare a written report after meetings, and maybe the tradition is that the minutes serve as that report.
We do a report at the end of each meeting on how we voted and why we voted. And we also do minutes so we can go back and review the case later if we need to.
Which, Harry, my understanding originally was that the report would suffice as our minutes. That's what Phil had told, Phil Noblet wasn't he our previous town?
If you do a report, that's as good as minutes. I mean, that can be your minutes. I'm not sure why you would need two separate.
And I may be thinking of, that may be more applicable to other boards that wouldn't necessarily have a written report. So I'll defer to the council on that.
Well, and two, you got to remember too that the Board of Zoning Appeals is if somebody appeals the board's decision, it goes to Chancery Court. So
Right.
you need your documentation for anything for court. Or some of the board.
You guys might want to look at the ordinance for the Board of Zoning Appeals.
I hadn't lately.
2-202 talks about minutes and the record of the meeting.
Yeah, I think a court would want to see the minutes of the meeting.
We'll say in all my other communities, we've been keeping minutes as well. So I would recommend.
It's part of our mandate to keep some kind of minutes. So if you read the section, it's got it in there, written minutes.
Okay.
Or report.
And Doug's going to do it for the next 12 months. So
Problem solved.
if he's
It's
voted.
been a while.
You okay with that, Doug?
Yes, I am.
Well, we
Appreciate
can't do status quo if we're putting Doug in.
There you go.
Well, I was just casting my vote, so you guys rock on with it.
Okay.
Why doesn't somebody nominate a president and then have a roll call vote and then
I
nominate.
nominate Dave Cantrell as chairman.
I second.
You're muted, Robert.
Yes, ma'am. I don't have to do anything yet.
Okay.
You just want to do a roll call vote? Chuck?
Okay, let me let's see. I have a list in front of me. I'll make one real quick here.
All right.
The, Gary. And Doug. Okay, all right, Dave,
Sure. All right, yes.
Bob,
Dave as chairman.
okay, Ashley,
Dave,
Carrie,
Dave,
and Doug.
Dave.
Okay. All right, we got the president for Dave as the president. So now let's do the vice president or vice chair, whatever you want to call it. Anybody want to make a nomination for?
I nominate Bob Griesinger.
Okay.
I second it. I second it.
Okay. All right, do another roll call here for Dave,
Yes.
Bob,
Yes.
Ashley,
Bob,
Carrie,
Yes.
and Doug.
Bob.
So VP is Bob. And nomination for the secretary,
And nominate Doug.
Second.
Vote for Doug.
all right, so roll call on that, Dave,
Yes.
Bob,
Yes.
Ashley,
yes,
Carrie,
Yes.
and Doug.
I accept. Yeah, me.
Okay,
For you all who are not on the BZA, the secretary is the most coveted role.
It is. You don't get paid, but it is.
It's supposed to be a town official, but
Yeah, I know.
we like to do it ourselves, so.
okay,
That's
so were there any minutes to approve?
Yes. You want me to go ahead and take over?
Yeah, I'm gonna give it to you.
All right, the meeting has been called to order by Chuck. So first thing up is the minutes. Did you guys everybody get a copy of August 27th, 2020 meeting, BZA 2020-06?
Yes.
Okay. Any changes or corrections to the minutes? That was the one for the side yard pool. If there are no corrections, I'll go ahead and say the minutes are approved. Next thing, we just wanted to go over, since and welcome Charlie and Harry again. We just wanted to go over some of the rules we have to go by. It's sort of a mini training session and a review for us, since we don't have any applicants tonight. And when we're finished with that, and interrupt any time with questions if you guys want to. And after that, we have a question about another section for Harry and Charlie. I'll just read through those. You guys interrupt me anytime you want, or if you fall asleep or something. The first power we have, which are obviously granted by the state and the city, we go by the city's ordinances and regulations also. And one of the first things we can do, which no one probably knows, Section 408, we can interpret zoning maps when they're disputed. If there are questions of lot lines or district boundary lines, if those questions arise, we sit and interpret those, believe it or not. I was going to run through a bunch of sections and we can talk about them if you guys want. Section 5, Article 5, 501, regulations are regarded as a minimum. The regulations set forth herein for each district shall be the minimum regulations and shall apply uniformly to each class, kind of structure or land, particularly except in the following cases. And that's Section 5. One of Section 505, which we've talked about in the past, That's a reduction of setbacks or lot areas prohibited. No setbacks or lots existing at the time of the passage of these regulations shall be reduced below the minimum requirements established herein. Setbacks created at the effective date of these regs. My update was 2014, but these were established about 1979, I believe. So setbacks created at the effective date of these regulations shall meet at least the minimum requirements established herein. And, we're going to jump to section 10. I'm reading from the appendix.
Dave, you've gone muted for some reason. Dave, you're muted.
Get my telephone. Call in.
I'm not sure why it's not unmuting. Are you seeing?
There we go.
There you go.
Now you got me, right?
Yeah.
I think I laid something on the keyboard, but it's my son's computer, so it works better for Zoom. Unfortunately, I don't know how to work it that well. So Article 10, one of the powers I wanted to talk about was appeals. Appeals to the board concerning interpretation or administration of these regulations may be taken by any person aggrieved by any officer, department, board, or bureau of the town affected by any decision of the building inspector. Such appeals shall be taken within a reasonable time period and by the rules of the board by filing with the building inspector and with the Board of Zoning Appeals a notice of appeal specifying the grounds. We'll get to a later section, but basically in an appeal, the Board of Zoning Appeals can actually act as a building inspector. But we'll find that rule a little bit later. In Article 1102, it says basically the same thing. One of our powers and duties is administrative review to hear and decide appeals where it alleged by the appellant that there is an error in any order, requirement, permit, decision, or refusal made by the building inspector or any other administrative official in carrying out enforcement or of any provision of these regulations. Section 1103 gets into special exceptions, what they are, and what we have to do to hear them. And Section 1104, we get into variances and all the conditions that cover those. And I won't read all those, but anybody that wants to or should review those, because it goes into all the things we need to consider when someone applies for a variance. Okay, section 1105 was the board has the powers of the building inspector on appeals, reversing a decision of the building inspector. I'm not going after you specifically, Chuck, so don't worry. In exercising the above mentioned powers, the BZA may, so long as action is in conformity with the terms of the regulations, reverse or affirm wholly or partly, or may modify the order, requirements, decision, or determination appealed from, and may take such order, requirement, decision, or determination as ought to be made to that end, and shall have the powers of the building inspector from whom the appeal is taken. So I'm just going over some of the duties and powers we have. Like I said, if anybody has a question or comment, feel free to jump in. Section 12 goes into a lot of the things that come to us for review, small animal hospitals, adult businesses, cabarets, massage parlors, all sorts of things like that. And a lot of rules in there we can look at to judge whether those meet all the requirements of the city. Continuing care, retirement, commercials, funeral homes, a lot of things we don't have, but if if they want to build here, a lot of times they have to come to us, and then some of them go to the town council afterwards. One of the rules, 1201.02, if we make a decision, like we grant a variance and nobody uses it within 12 months, then they have to reapply and come back. They can't just keep it forever. And Board of Zoning Appeals, 1201.03, we shall not rehear any case on the same grounds within a minimum period of 1 year. So. No questions so far, Charlie? Okay, you asked about this earlier. Article 1301 is method of appeal. Any person or persons, any board, taxpayer, et cetera, aggrieved by any decision of the Board of Zoning Appeals may present to a court of competent jurisdiction a petition duly verified setting forth that the decision of the BZA is illegal in whole or in part, specifying the grounds of the illegality. So I guess you need that. They can't just say, I don't like it. I mean, they could, but. And that has to be done within 30 days after our decision is made. Then after that, they have a procedure in court that they have to follow.
Can I address one thing real quick while you're there, Dave?
Yes, please.
There was a fairly recent case, I think out of Manchester, just talking about the timing of the appeal. And the BZA in that case didn't do a written report, but they did do minutes.
Okay.
And their minutes, you know, they did the minutes and the minutes got approved, I don't know, 2-3 months after the initial meeting. The people who were unhappy with the BZA decision filed an appeal of that within 30 days of when the minutes were approved by the BZA at the subsequent meeting. Question came up, well, is that timely, or should it be 30 days from when the BZA actually conducts the hearing and makes the decision? And I didn't look at that before today, but I think that what the Court of Appeals ended up saying is in that situation, the 30 days would begin to run from the time the minutes were appealed. I mean, the minutes were approved, because that was the written report.
So that makes it sound like.
And I don't know that that applies particularly to what you all do, but
Yeah.
timing is important. And it doesn't necessarily mean 30 days after you make a decision. I mean, after the BZA meeting at which a decision is made, that they have to appeal.
Some of the stuff I've read said a lot of times the court will send it back to the BZA because all remedies haven't been, utilized or used. Does that happen more, or does the judge just make a decision? Do you know?
Generally, the judge makes a decision.
Okay.
And frankly, I don't know how many. I don't think there are a lot of BZA cases that get to court.
Yeah, I haven't seen any so far, which is good.
Do y'all think that minutes can be approved through email, or does it have to be at the next BZA meeting so that we can maybe do this in a timely fashion?
I think, well, I'll let the lawyers answer that question. Go ahead.
I don't know that I know the answer to that question.
My first thought is you probably have to do it at a public meeting, but I don't know if that's correct or not.
I think if you're referring to starting the time period for somebody to appeal, if you look at 1301, it says the petition shall be presented to the court within 30 days of the filing of the decision of the Board of Zoning Appeals. So it doesn't really have anything to do with the minutes. It has to do with whatever report you guys make that has to be filed with the town. So whenever that's filed, I'm not sure the process for that, but whenever you guys sign and file it.
I agree. That's correct. And my point in bringing up that other situation was, in that case, the BZA didn't do a written report. They simply relied on the minutes. I think from previous discussions we had at town council, I think minutes have to be approved at a meeting itself. Because I recall discussions about could the draft minutes be put on the website so people will know, essentially what was discussed. And I think we decided that that could be done, but it needs to be clear that at that point, those minutes are only drafts and haven't been approved.
Are the other bodies in town doing that as well, or just?
I'm not sure what's being posted.
Okay. All right, but something we can definitely talk about. Do anybody have any questions over what we've covered so far? Or any input? I'm not trying to steal the show by any means.
So any change in a variance decision by the BZA has to come back through an appeal process to the BZA?
No, it goes to court. If
There you go.
someone's not happy with us, yeah.
Okay.
Sometimes the judge will send it back, but as Harry said, most of the time they just make a decision, probably get it over with.
Is that the exclusive way to appeal a BZA decision?
Yes.
Uh-huh. Okay.
May I say something, Chairman?
Go ahead.
Along the way, I've gotten kind of interested at times in how other townships, cities, usually small towns like us, how they go about their BZA process. And a lot of the same regulations and are very similar to other places.
Because of state regulations?
Because of state regulations, yes, you can. I've looked at several of them, and not into great detail. It's very time consuming if you want to really get into the weeds and all. But it's a lot of the process is very similar.
Hey, David, this is Bob.
Go ahead.
What Charlie brought up, I think is relevant because it says, let me get started right. Such petition shall be presented to a court within 30 days of filing decision of the Board of Zoning Appeals. Our decision is made at the end of the meeting or tomorrow or in a couple of days here. We will all go up there and sign how we voted.
Right.
And that will have the resolution on it saying what our decision was, and we will all have signed it. At that point, I would say that is the 30 days from when that's done.
I agree with you. I normally do that at the meeting, so.
I don't think the minutes have anything to do with it.
Now, I agree, and I shouldn't have brought that case up, but my point in bringing that case up was that BZA did not do a written report. If there isn't a written report, the minutes become it. So I'm not saying, that's all I'm saying. If some BZA somewhere doesn't do a written report and only does minutes, that becomes its written report. If you all do a written report much sooner than the minutes get approved, that's great. And that's when the 30 days would start to run.
So if it takes us 2 weeks to get up to town hall and sign it after a Zoom meeting, that's when the clock starts.
That's correct.
Okay. All right.
As Ashley and Harry can attest, the reason lawyers have jobs is because somebody doesn't do theirs. So, and that's why, I mean, I think that's why you get a case that's appealed, like Harry was talking about, is because somebody didn't do their job, something was messed up, and then, they're trying to figure out a way to make that either work or not work, depending on what side you're on. But if that, what municipality, whatever municipality it was, if they had done their job, they would have filed their decision like they're supposed to, and we wouldn't have had this appellate decision.
All right. Does anybody have any comments? Ashley, I haven't heard from you tonight. She's still there?
Here, I don't have any.
Nothing? Okay. Yeah, part of the reason I was doing this is just, it's a good review for us. And since Charlie's new, although I think he's read most of this stuff already, you and I talked about it a little bit. We sort of wanted to talk about that case since we have Harry and Charlie here, about the setback reduction out on Palisades using sections 603, 02. I guess we just need to, since we have been using for years the 40-foot setback. So this is something different for us. And I guess we need a clarification exactly. Carrie, did you want to read that email from town
Sure.
manager, Boyd?
So this is in response to my email inquiry to the town manager as to why he got involved in a variance case that had already been decided upon by the BZA. And he responded on December 9th, CC'd Harry, town council members, and the board members, BZA members, because that's who I had CC'd in my inquiry. Carrie, section 603.0202 of the zoning ordinance establishes required lot size and setbacks for LDR properties. The following is found in that section. For minor subdivisions being developed within an existing subdivision, the developer shall use the most frequently occurring front setback on the street. The same shall apply for a single infill lot, as amended by ordinance number 2013-18, which is September 2013. This is not an appeal or a variance scenario, but a standard, the specifics of which must be determined in each individual case. Most folks go with the standard minimum setback, but if they inquire as to the true minimum setback for a particular lot, based on this provision, we then have to make that determination. Once we determine the most frequently occurring front setback on the street, they are allowed by code to use that setback if it is less than the standard. There is no need for a variance or appeal, so it would not fall within the BZA's purview. Let me know if you have any other questions, Boydville Town Manager.
Yeah, I have a couple. Well, Harry, I guess our problem with this was that lot that's out on the town perimeter. I mean, to me, the double asterisk there says for a minor subdivision. And I think the infill lot is also, is what that's referring to, is in a minor subdivision. But it sounds like Boyd wants to apply it townwide. And I think that's sort of what's getting our attention, you know, because we need to have I think, a set of standards. You know, these are the setbacks. You know, if it's 2 lots in a minor subdivision, I can see that. But on a long city street that's 3 miles long, I'm not sure.
Well, the way this should have gone in a perfect world is the property owners, had they contacted the staff initially and asked, what is the setback for this property? Then I think the staff determined, I think correctly, that this is an infill lot, and therefore you use the what is it, most commonly occurring setback for houses on the street. I think that determination would have been made, and then once the determination was made, and I think it was 39 feet, then if the property owner either disagreed with that finding, the property owner could have appealed that finding to the BZA, or
Go ahead, I'm sorry.
Or if they said, well, 39 is better than 40, but it's still not good enough, we need a variance from the 39, then they could have asked the BZA for a variance. This one just sort of got backwards because they, I guess, assumed that 40 feet was the setback, and the town administration determined that's not correct. And I think that's the town's, that's not the BZA's decision to make as to what the setback actually is. The BZA can determine, given the setback, is this variance justified?
Well, how does that, which is the superior rule? 505 says reduction of setbacks are prohibited. So is the thing for the minor subdivision superior to that?
Well, I don't think that was a reduction of the setback. I think that was a calculation of the setback, given it's an infill lot.
I've been doing this for a long time, and this is the first time we've ever seen this happen. So I'm wondering if this sentence is being misconstrued, because that lot's obviously not in a minor subdivision.
Well,
And it's
I think though that it doesn't necessarily have to be, I think it's saying it's for infill lots as well, not
Then what-
necessarily infill lots in a minor subdivision. And I think the real problem is that the term infill lot is not defined in our code section. But if you look at the definition of an infill lot, it can just be a remaining lot within a city. But if
Right.
the real problem is that maybe we should put a definition for infill lot, but when I read it, I don't see that infill lot is only in a minor subdivision.
Well, maybe it should have its own paragraph, because that's the paragraph it's in. You know, the whole section's talking about subdivisions. That's not a subdivision. So, yeah, I see what you're saying, but it's like, if we're going to apply that, it's, plus I think you're sort of opening a can of worms. What if 3 houses that are next door have variances for a creek or a ditch or a cliff? We're still going to take the average, you know, that, how do we know they all have complied with the zoning regs?
Well, I don't think they took an average.
I think they did. They said they were between 38.8 and 40 feet, so they gave them 39 feet.
Well, they
most
did
frequently occurring.
some
Yeah.
rounding to get to that, yeah.
Yeah.
Well, I think if this 603-0202, if the single infill lot only applied to the minor subdivisions, I think it would have said that, instead of saying minor subdivisions, period, and then adding a separate sentence.
Well, I guess I read it as it's in the same paragraph under minor subdivision. So that's why I guess
I mean, nothing's,
do I?
well,
I haven't read the law like you have. so-
nothing is concrete.
So an infill lot has nothing to do with filling in dirt and earth and that sort of thing?
No, Doug. I got a question, David. This is Bob. I seriously question how you can have an infill lot on an undeveloped area. These lots were defined. The infill lot whole idea is like Old Town, where we have some extra space that we really don't know what it was. Somebody put a house on a 3/4 acre lot, and so at that time they could change the set on it. So then you could end up with an infill lot. Since 1979, when we passed these regulations, everything had to be according to 505. And we can't go back and kind of change that. And as far as I can see, I have no idea how the Planning Commission has the ability to go ahead and give special exemptions. The only people that can give special exemptions are the BZA. We can go bouncing around all kinds of words, but you got 1100, 1200, and 1300 that all say that is not the Planning Commission's job.
Well, I agree with you. An infill lot, I think of as in an established neighborhood and a vacant lot, whereas this was a 4-acre lot at the edge of town. I don't consider that an infill lot, but I guess with our liaison here, this is what we need maybe to.
Well, you got 16, 17 acres there. Are we going to call all those infill lots? so we're going to develop one at a time. I even at that point, I think they have to be half-acre lots, and I have to think they have to have what 505 says, the standard setback.
Well, I happen to know the person that wrote this paragraph. I live with her. And that's not what the intent was, to apply this townwide. I think it was for minor subdivisions only. But I guess what I would ask our liaison is are you still on the planning commission, Charlie?
I am, yeah.
I guess what I'm asking for is if you guys can either clean this language up or just get rid of it or something to make it, I think about the workload for Chuck and the town too. If every single building permit, they've got to go out and measure all the houses in the area. I mean, it seems like their workload's going to balloon.
Or perhaps someone can define what a minor subdivision is.
Well, and the infill lot.
Just to answer your question, I think, yes, it's something that either the town council or the planning commission or both should discuss, because there is maybe some room for interpretation. I don't think that this situation applied personally, but I do have a question, just not as a council member, but just as a regular citizen. And that is, from a legal standpoint, if somebody starts the appeal process through the BZA, aren't they bound to complete, to go through with that process? Because it seems like in this situation, they went to the BZA, they got a decision that they didn't like, rather than following the procedures of appealing to court or coming back to the BZA with an alternative, they went somewhere else and got another decision. That seems like from a lawyer standpoint, it seems like filing suit in Chancery Court and getting a decision you don't like, and then going and filing suit in Circuit Court.
I agree with you 100%. I don't understand how our town manager can't figure out that he's supposed to follow the rules. And the appeal for the BZA is the courts.
Yeah, I don't know why decisions, what was decided and why, but I'm just asking Harry, does that make sense? Is that something that should have been done?
Yes, it's like after they didn't like our decision, they sought help from the existing mayor and the town manager. If I can maybe give you a scenario and elicit some empathy here, it's a very uncomfortable feeling as a board member to know that someone who's essentially taking the role of an appeals court judge and can overturn our decisions and without our knowledge to boot. I mean, it would have been nice maybe if Boyd even called Dave and to let him know and said, hey, we're taking another look at this and we think it may qualify as an infill lot, and I'm considering allowing a setback difference, just out of respect for what the Board of Zoning Appeals does. Because it was just dumb luck that we figured out, his role in this latest case. So maybe that's kind of what Charlie's saying is did the applicant go through the correct process if they were unhappy with our decision?
I guess my problem with this interpretation of this rule is we have to give a public notice of 15 days when someone applies for a variance, whether it's 6 inches or 20 feet. We have public input. Neighbors can come testify if they want to. But this is all done behind closed doors. You just don't know that it's happening at all. At least I didn't.
Well, I think part of it though too, and the real beauty of the law is that it's it's not defined. Infill lot is not defined. And so therefore there are 2 standards for that lot that we have legally set forth in our code section. I mean, if you want to define it as an infill lot, there's no definition in our code so that you could argue that it wasn't an infill lot. I mean, we can sit here and argue this back and forth all day, but there's no definition and both of us could be right. So
that's
I think
what I'm saying, that it should be cleaned up and defined.
Right. So if there was a definition, but I don't feel like that anything was done incorrectly here, because I think both standards, I mean, it could have been 40 feet, or if it's an infill lot, it could be this. And as an individual, I think that they could argue it both ways and they may have a legitimate case either way.
Yeah, but about 3 or 4 places in our rules, it says there will be no reductions. So now we're saying this allows reductions all over town, and I just
Well,
agree with that.
My thinking with that is, though, I think that it does give some flexibility in that neighborhoods have been established. And if you have all of the houses are set way close to the road or way back from the road, there is a desire to me to keep something in keeping with the neighborhood so that one person isn't looking at the back of everybody's house. And so I can see using this language to allow that to happen.
Well, we do have small, anything built in 79 is probably 40 feet, but we do have small lots of record to deal with that. You know, if it's a small lot, you can build a house 20 feet from the road.
Well, I understand that, but to me, a small lot of record, I mean, an infill lot to me is the same. You could say it's an infill lot, and this is the way you determine it on an infill lot, the same way you do a small lot of record.
Right. Okay.
So I just don't have I'm not really that upset about this, if you want me to be honest. I don't think there was any malintent.
Actually, help me to understand, did the town manager act within his role?
I feel that he did.
I feel that he did.
Well, see, is this a case too where someone could appeal to us and go, we think the town made a mistake in the building permit, and would come to us for an appeal?
I don't see how anybody can read this regulation and not see that it's not 2 lots to make a minor subdivision. It says it pretty plainly, and 1 lot does not make a minor subdivision.
Yeah,
I don't care how Boyd wants to read it.
Did we cut you off there, Harry? I think you were going to say something.
I've forgotten where I was going, what we're talking about, frankly.
Well, this is why I wanted to meet when we didn't have any applicants, so we could just bounce this around and talk about it and see what everybody thought.
I think it's good, and if, you know, y'all, I'm glad to talk to somebody anytime y'all want to call me. Charlie, let me address your question. I don't think going to the BZA and requesting a variance from the 40-foot setback waived the property owner's rights to question what the actual setback was. Now, if they'd gone after the Board of Zoning Appeals, if they'd been told that there was a 39 foot, that 39 feet was actually the correct setback, and they said, well, we want to go back to the BZA and ask for 14, I don't think that would have been proper because that request essentially had already been responded to. The BZA didn't rule on what the setback is.
No.
That's why I don't think that was waived.
Well, I saw the email chain, and they basically went to the town and asked for about the same variance they asked us for after the case was denied.
And they didn't get that.
No, they didn't.
I mean, I know they ended up with a 39-foot setback, and I was surprised to hear that they actually, well, I don't know, have they already built or started building?
I haven't seen, this stuff was back in September, so
Yeah.
probably so. I mean, I don't want to try and stop that now. I just want to clean it up for future use. You know.
Chuck, is that house started yet? Is that the place we're talking about?
Yeah, the foundation is built, and they're in a holding pattern right now because they're waiting on steel.
Boy, I'll tell you what.
Does
this was a classic case. He was just trying to get as much as he could. If they'd come back for probably a lesser set, you know, I don't know, wouldn't have been 12 feet. They probably could have gotten more than don't quote me on this.
Yeah.
I mean, they probably could have gotten more than, I don't know.
Hey, the internet lasts forever, Doug.
I hope it's not on record.
Could somebody educate me now? So the town manager can step in if the applicant's not happy with a BZA decision, or when does the town manager, when does he do what he did? Like when? How does that work?
Well, I think it goes back to what Harry said, that ideally, originally, they would have determined that this was the setback, but it was kind of done backwards. So
Yeah.
I don't think that the town manager was really stepping in and overturning something that we had done.
So when is he allowed to do what he did? Like,
When
he
he's
complained,
asked.
he complained that his staff spent a lot of time having to survey the setbacks on the entire road. I appreciate his efforts. I like Bo, okay? I just want to know when he's allowed to step in and do what he did. Like, what's the protocol?
Well, when he's asked to determine what a setback is, he has the authority. Probably he's got the obligation to do that. He or his staff.
I see.
Even if it's not a minor subdivision?
Well, that's a determination that they under the reading of this 603.0202, he didn't read, and I don't read that to be limited to a minor subdivision. I mean, that's the decision that they made. I personally think that it was correct.
So the requirements for minor subdivision don't apply.
No. It can be a single infill lot, not necessarily in a minor subdivision.
I think that's something that we'll take back to the planning.
First condition.
Well, I think it's something that needs to be clarified because it's subject, like Ashley and Harry both said, it's really subject to different interpretations.
I don't know how you get a different interpretation of the first condition, lot subdivided into more than 2 lots. That's a minor subdivision. That has not happened. If you want to sit here and pick and choose what lines you're going to pay attention to, then we might as well not write regulations.
Well, the problem when you write regulations is someone, or not, I shouldn't say someone, but at times what you write seems to be fine, and then there's a challenge to it, and you realize maybe it wasn't fine, we need to fix it. So, things come up, and as a result of things that come up, there's amendments that are
So
done.
at this point, I would ask the board, the BZA, to ask the town council to rescind 602-02, period.
Yeah, I mean, I can take that request back to the town council, but I think
The planning commission wants to make some other recommendation, fine, but this regulation is obviously flawed.
Well, it just needs to be amended to clarify it.
Well, I would call anything that's wrong flawed. So, I mean, you can take anything, amend it, and then it's correct.
That whole 16 or 17 acres in there has had development issues going way back. This is nothing new. I knew the fellow who had that and mentioned it the last time. He lived here. He was a West Point graduate, played football, and worked out with his son, Mr. White, going way back. And I can remember talking to him this goes back to the early 80s, and him telling me of some of the development problems with that property. And at that time, I even had this idea that I was out of college, and I was working. I thought maybe I would try to buy it. It was so pretty, but they were right across from the brow. It was desirable. And but I came away with it was going to be more problems than I wanted to take on. So, but all I'm saying is that property, this is not new. It was expected, just about.
Let me ask Charlie. Charlie, do you need any kind of formal letter asking us to clean this up? Oh, I guess.
No, I don't. I mean,
all right.
Harry probably can answer that question, but I think the role of a liaison is to take questions and things.
Right. All right. Well, I think we've probably talked about it and made our feelings known. So I'm ready to let you guys go back to dinner if you're ready.
Now, I just have a question, Dave, if
Okay,
you don't
all
mind.
right.
I'm not making a statement. I'm just asking. Does the building inspector need to let us know if there's been some sort of change or modification after we've made a decision?
Not one that great, because he asked for a 12-foot variance and then this thing was by another method of 12 inches, but I wish there was a notification process but I don't think there's one in place right now.
Yeah, I don't think there's a process for the building inspector to report back to BZA.
No.
So then we never know if the applicant followed through with our decision, right?
Well, Chuck won't give him a set variant. He's not going to change the setback for something we didn't give him a variance on.
Got it. This has been really educational for me. I know y'all think, gosh, this chick's fired up about this. But I feel compelled to kind of protect the board's authority. So I want to thank y'all for this education.
Yeah, thanks, everybody. I appreciate everybody coming and communicating with us, and we got a lot of work done that we don't have to do when we have applicants waiting. So that's good.
Good.
Does anybody else have anything?
No, thank you, Harry.
Yeah,
Thank
thanks,
you all.
Barry, and welcome
you.
again, Charlie.
Thank you.
All right, we'll go and adjourn the meeting then.
Hey, do we need to get down to town count to the town to sign this thing so that the clock can start?
On the minutes, no. Oh, the
There's
decision,
no
yes.
decision to be appealed.
You're talking about the previous decision, Carrie?
No, like this meeting.
No,
Just sign
there's-
off on this meeting.
No, there's nothing to sign.
Except for what about the nomination of officers?
I'll include that. And-
Do we
and-
need to
and-
sign off on that, Chuck?
I'll,
I think
I'll
that's,
pass something around.
that's part of I think that's just part of the minutes for the next
Yeah.
meeting.
Yeah.
There won't be an appeal of that unless Doug chooses to appeal. I don't think.
We'll have to see how much Doug is appealing.
Yeah, really. All right, y'all.
Good to see you, Ashley. Thank you, Charlie.
I